Hi, my name's Liz Stephen. I'm a solicitor partner at Ison Harrison. I've been doing this job since 2002. The starting point in English law is something called testamentary freedom. That means the person has the right to make a will leaving their money to whoever they want to, whether it be charities, neighbours, friends, whoever. You can leave your money to whoever you want to. However, there are certain people who would be left out of your will if you did that, and if you were financially supporting them, they would have the right to make a claim under the Inheritance Act. So say for instance, if you cut your spouse and your children out of the will and they were financially dependent on you, obviously they would have a claim on your estate. To make a will, in the first instance, a person needs what we call full mental capacity. That means they need to understand precisely what they are doing, that they're making a will, they have obligations to certain people, such as children, and they need to know the extent of their assets, the approximate value of the house, and roughly how much they've got in the bank. If a person does not have capacity, then the will can be challenged. So if they have severe Alzheimer's or dementia, then the medical notes at the time the will was made would indicate that person lacked capacity, so the will could be challenged on that basis. Another way of challenging a will is if the will was made under something called undue influence. That is where somebody is coerced into making a will, leaving all their money to some random person that defies logic. And if you can show that undue influence was used, then the will can be contested on that basis. Further, a person must understand what they're signing is a will. It's called knowledge and approval. So if a person is tricked into signing a document that they don't know is a will, well, obviously it can be contested. If a beneficiary is having issues with a trustee, they should go and see a solicitor, and first and foremost we would try and resolve this matter amicably by getting the trustee to step down amicably in agreement and appointing a new trustee in place by way of a deed of appointment and retirement. If the matter cannot be resolved amicably, then we can go to court on behalf of the beneficiary or beneficiaries and have a trustee removed. But to do so, you must have really good grounds for removing a trustee. Not just a personality clash or you don't particularly like them, you need a really good reason to do so. Inheritance Act 1975 is an act of Parliament that allows certain people to contest a will if they feel they have been inadequately provided for. If somebody makes a will and does not make adequate financial provision for their dependents, then their dependents can contest the will on that basis. So if, for instance, a testator, the person making the will, cuts out their spouse or dependent children or handicapped children or somebody else like a stepchild that they're maintaining financially by providing them with a roof over the head or an income, then the disappointed beneficiary can go and see a solicitor, discuss the case and see if there is any merit in contesting the will. It has to be done quickly. There's a very strict time limit on this, and if you are going to contest a will and it can't be resolved amicably, court proceedings must be issued within 6 months of the date of the grant of probate. Every case is looked at on its own merits, and there's a pecking order of people who are entitled to contest a will. They would look at the deceased's assets and circumstances, and they would also look at the assets of those people, those disappointed beneficiaries. We deal with a whole range of disputes. Powers of attorney disputes are very common. A power of attorney is a legal document that somebody makes when they've got capacity, appointing somebody in the future to take control of their finances. Often attorneys fall out between themselves, or they fall out with the family of the donor, the person making the attorney. Deputyship disputes are very similar. Trust disputes, again, there are often conflict between beneficiaries and the trustees. Will disputes are becoming more and more common because family breakdown is becoming more common. It's not unheard of for people to be married 3 or 4 times and have children from various relationships and leave everything to their 4th or 5th spouse when they pass away, cutting out the children from previous relationships. They often lead to some very, very acrimonious disputes involving step-families, etc. As far as possible, we resolve disputes amicably and by negotiation. So what we would recommend is that the parties in dispute see separate solicitors. We would negotiate with the other sides of solicitors, the other firm of solicitors rather, to try and resolve the dispute amicably and settle it without having to go to court. Going to court is an absolutely last resort, because it's expensive, it takes forever, and more often than not, disputes are resolved amicably between firms of solicitors. If there is a dispute between the beneficiaries themselves, they would each go to separate solicitors, and again we would try and negotiate a settlement. If there was a dispute between trustees and beneficiaries, the same would happen. There are more simple ways, however, of avoiding inheritance tax than using trusts, such as lifetime giving. If you give £100,000 away to your children and you live for 7 years, that does not form part of your estate in terms of inheritance tax. Gifts to spouses, give it away or spend it, is often the best inheritance tax advice you can give to people. You're allowed to give away £3,000 annually without inheritance tax becoming due, £5,000 on the occasion of your children's marriage, £2,500 on the occasion of a grandchild's marriage, and that passes free of inheritance tax. A key thing to think about though is making gifts out of income. If you have what we call a taxable estate, if you're wealthy and you fall into the inheritance tax bracket, what we recommend you do is you start planning as early as possible, giving money away, putting assets into trust, spending it. The earlier you start, the better, and if you leave it too late, well into your 80s, early 90s, then often your estate suffers a major tax hit when it could have been avoided had you started planning much earlier in your 60s and your 70s.